Very interesting article coming from Elaine Watson. PTAB invalidates Impossible Foods patent filing challenge by Motif FoodWorks, but denies request to review 6 others. June 18, 2024. Elaine Watson. The United States Patent Trial and Appeal Board, the PTAB, has invalidated 23 out of 24 claims in an Impossible Foods patent following a challenge by Motif FoodWorks, but denied request to review 6 other patents also at issue in a high-profile legal dispute between the two food tech firms. The parties are embroiled in litigation over the use of meaty-tasting hemi-proteins in plant-based meat alternatives, which began in March of 2022 when Impossible Foods accused Motif of patent infringement. Impossible Foods' hemi-protein is identical to soy legumoglobin, a protein found in nodules attached to the roots of nitrogen-fixing plants such as soy. Motif FoodWorks' hemi-protein is identical to bovine myoglobin, which is found in the muscle tissue of cows. Both are produced via precision fermentation using a genetically engineered strain of yeast. Impossible has accused Motif of IP theft, while Motif argues that the parties' proteins are different, and that many of the inventions claimed in Impossible Foods patents are obvious and disclosed in the prior art. So, PTAB. Motif has proven that claims 1 through 12 and 14 through 24 of the 096 patent are unpatentable. The lawsuit originally focused on a single U.S. patent granted to Impossible Foods, 10,863,761, but has subsequently been expanded to cover a suite of the company's patents. These were in turn challenged by Motif at the U.S. Patent Trial and Appeal Board, the PTAB, which asked the PTAB to institute inter partes reviews, IPRs, of all the patents at issue in the litigation. According to the PTAB, 6 of the 7 of Motif's IPRs, the inter partes reviews requests, have been denied, with the PTAB concluding in each case that Motif has not demonstrated a reasonable likelihood that it would prevail with respect to at least one challenge claimed. However, the PTAB did agree to review Impossible Foods' U.S. patent 9,943,096 and issued a final written decision on June 12th concluding that Motif had proven by a preponderance of the evidence that claims 1 through 12 and 14 through 24 of the 096 patent are unpatentable. The patent in question, methods and compositions for affecting the flavor and aroma profile of consumables, covers a ground beef-like food product that contains no animal products and that when cooked results in the production of at least 2 volatile compounds which have beef-associated aroma. What impact do the PTAB cases have on the related litigation? It is too early to determine what impacts the PTAB's final written decision on the 096 patent may have on the ongoing litigation, with Impossible Foods noting in court filings on June 12th that the decision is subject to rehearing and/or appeal wherein it may be reversed or modified. Final written decisions from the PTAB on the validity of patent claims can be admissible in related patent infringement litigation, where defendants in such cases have argued that you can't infringe a patent that the PTAB has found to be invalid. However, preliminary PTAB decisions to review or not to review patents are not generally admissible, with Motif telling Food Navigator USA in late 22 that the PTAB decisions to deny Motif's request to review other patents filed by Impossible Foods cannot be admitted into evidence during a jury trial. The Impossible/Motif litigation, now well into its third year, has taken many twists and turns, with Motif recently accusing Impossible of hiring private investigators to covertly obtain info about Motif's products, something which the court found did not violate rules of professional conduct. Meanwhile, a decision by the European Patent Office, the EPO, to revoke an EU patent held by Impossible Foods in late 2022 has no bearing on its legal dispute with Motif in the US, according to Impossible Foods, which has appealed the EPO decision following the proceedings at this link. Impossible Foods did not respond to a request for comment on the latest developments at the PTAB or the ongoing litigation, while Motif FoodWorks told AgFunder News that at this time we have no comment on the ongoing litigation. The case is Impossible Foods versus Motif FoodWorks, case number 122-CV-00311, filed March 9th, 2022. End of article. So this article is quite revelatory, and unfortunately, it's quite heavy when it comes to the patents and it comes to the fact that this is really the third year of the litigation. So both these companies are trying to protect their intellectual property, if you will. One side insists that it is patentable. The other side said it's not, and the other side says that it's actually not even similar and quite different. And they're pointing to the actual chemical structure and biology, if you will, of the input for their ingredients and the foods that they are creating. So unfortunately, it's a bit of an ugly story. Um, but this is where the rubber hits the road and the lawyers get involved, and now it's in litigation, and both of the companies are not going to, at this moment, it seems, make any comments because it's still being litigated, and that's the really the default setting for any company is to not comment on ongoing legal cases. So hopefully this gets resolved sooner or later, unless both sides get completely bled dry by the lawyers. But yeah, this is an interesting article for those of us who haven't necessarily been following it, because it really does a very good job of explaining the lawsuit. It explains a good job of the science behind both sides of this disagreements, where they stand. And then yeah, from there it just talks about what are the next steps. And it seems that with 3 years into this litigation, it's probably going to continue to drag on, and you would hope for each side that they're able to stay cash flow positive and maintain profitability in their own market segments, even though they overlap considerably. Otherwise, if it were to be truly make or break for these companies, then it could really grow uh, the weight of the lawsuit itself, because it could be existential, some of these patents. But it seems that that's not the case, or at least it's not explicit in the case, because these are two big companies with rather large footprints in their industries, but they're competing for shelf space and market space, and this lawsuit is case in point for that. So looking forward to getting more legal updates on this lawsuit between these two industry competitors.